Hello, and thank you for choosing the Legacy Lawyers as your source of information. We know this might be a difficult time you are going through, but we are here to educate you and help you through the process. Please stay tuned for our question and answer portion.
Good morning, Aaron.
Good morning, David. Enjoying the beautiful weather outside?
From in here, no, but I know it's out there.
Well, that's good. At least we know it's out there.
Exactly.
Okay, so, we've gone over, what a will is, and we're going to continue to go over wills and will contests. So for today, what are the grounds for a will contest?
Okay, there are main categories. There's the most basic, commonly understood category of contesting a will, which is lack of capacity. That means that the person who executed the will lacks sufficient mental capacity to knowingly sign the document with the intent to dispose of their estate to such and such people. This person had a lack of a presence of mind to understand the nature of their property, the nature of their familiar relationships, and the consequences of what they're signing as it relates to their property and the relationships. There's also undue influence in which someone has a specific type of relationship with the decedent. It's commonly called a confidential relationship in which they exchange confidences in each other. This is a decedent who, when they were living and when the will was executed, was vulnerable for some reason, whether that be mental impairments, physical impairments, a combination of both. With this person who is benefiting greatly from this will. So you have a vulnerable person, you have a special relationship with the person who's submitting the will between the decedent and that person. You have the person who is benefiting from the will, they have in some way actively procured that will, meaning that they found the attorney or they logged into LegalZoom or did all the paperwork, drafted the will, maybe facilitated communication between the decedent and this attorney who's never met the decedent, and said, well, here's the paperwork, and reports to the attorney, this is what she wants, please draft it up, gets it drafted, pays the attorney, goes to the decedent and say, this is what you want, sign this. And the decedent, having this special relationship with this person, a relationship of trust and confidence, says, okay, well, you take care of everything and I believe you, or I have no choice but to believe you, and I'll sign it. And as a product of this document, it's an undue benefit, meaning the decedent had 20 children and 100% goes to one. That is an undue benefit. Whereas under the natural disposition of this person's estate, each person would get 5%. Now this person gets 100%. There is also the possibility that the will was procured through fraud. Fraud is a material misrepresentation to someone. So namely, someone who has procured the will is making a misrepresentation as to the effect of the document to the decedent while they're alive. And that decedent relies on those misrepresentations and signs the document. Like, let's just say I have a confidential relationship with Graham, and I say, well, this is going to authorize me to pay your bills, or this is going to authorize me to keep the lights on because your name is on the power bill and mine isn't, or so on and so forth. And they say, well, I don't want to live in darkness, so yes, please, thank you very much, and they sign it. So that is a type of fraud. There's also duress, meaning the unlawful or harassing concealment of personal property. Not concealment, I'm sorry. Not concealment, sort of like imprisonment. Or basically you keep someone in the room. You say, Grandma, you are going to sit in that chair and you're going to be there. And this is the ticket out. You sign this document and we'll go to the senior center. Or I'm going to somehow impair or frustrate your ability to access your property, or so on and so forth. Some sort of confinement, which result in the decedent or the testator. We're talking in the present tense as if they're still alive, so I'm going to switch over to testator. So the testator some sort of confinement that results in the testator's free will sort of being overwhelmed, and they sign the document. Then there's menace. Menace is some sort of threat of unlawful or harassing threat of harm to person and or property. So, okay, so you know The Godfather. So in The Godfather, there's one of the most famous quotes, which is, "I'll make him an offer he can't refuse." That is an offer that indicates some sort of menace. For example, when Michael Corleone talks to his wife and wants to say, well, that's my family, it's not me. And there's Luca Brasi, who's the tough guy who works for Don Corleone. And they had a family relationship with a Frank Sinatra type character. And they wanted that Frank Sinatra type character to be released from his contract with this other agent. So the Don and Luca Brasi went over to the agent's office, and Luca Brasi put a gun to his head and said, I can assure you one thing, either your brains or your signature will be on that release. That is menace. That is an unlawful threat of harm resulting in the signature of the document. So usually guns aren't used to unlawfully procure a will, but it could be something more nuanced. For example, Grandma, I'm going to you're at home and I'm going to put you in a boarding care facility. And I know you're fearful of that. But if you don't sign this, then I have no reason to be here. And no one else in the family lives close by. I'm sort of threatening you to sign this so that I have some skin in the game and I'll stick around. Stuff like that happens. Or just anywhere in the continuum of threats, which result in the testator's free will being overwhelmed and they sign off on the document. It could be even a threat of withdrawal of support. So, for example, the testator may not be ambulatory. They might not be able to walk, and they're in their house. It's a 2-story house. They can hardly get around. They can't go out and get food or water, and they need help, assistance in getting to bed and bathing and so on and so forth. And the person attempting to procure the will say, well, wouldn't it be scary if I wasn't around anymore? Because I'm thinking about starting a new life in Flagstaff, Arizona, and I want to move out there. I mean, it's beautiful out there, but I'm sitting around and I'm taking care of you, and I'm very ambivalent on the issue. I'm having serious doubts, and I really wish that I can stay here because I like taking care of you, but I'm being pulled away. By the way, would you mind signing this document? And then the fearful testator says, oh, well, I better keep this person happy as long as I can. Mm-hmm. So, and I can't take it with me, so I'll sign it. So that is a more nuanced example of menace. There's also mistake. Mistake means that the testator didn't understand the legal effect of the document. And in the context of will contests, it's that they didn't have an understanding that this document was of testamentary intent, and they made a mistake in signing it. And then there's, there's also invalid transferees, which means it's sort of a separate conversation, but a gift to someone who is a care custodian, that's someone who provides caregiver services for compensation. And that is not also a blood relative, or there's other exclusions, but someone who is essentially a straightforward caregiver getting paid. And gifts to them are presumptively invalid. And that might be a gift in the will. So, or someone who is not related to the decedent and participated in drafting the will. So those are some other examples of how a portion of the will or a gift to someone through the will is not valid. And it's up to them to overcome that presumption.
Okay.
Fair enough?
Sounds good.
Okay.
Thank you so much.
Sure.
And if you guys have any further questions, feel free to email us at smm@thelegacylawyers.com. Have a great day.